Great point brought up by you, Ewok. Yeah. So we had some updates from Richard Hart's attorneys as they look to get rid of these yucky people within the SEC after they came basically for a monetary shakedown of Richard Hart. Hopefully Gary Gensler will be gone soon and we can get past this. And I don't think people are even really worried about the SEC anymore. And that's a bigger conversation I want to have with you in a minute about a poll that Toby Wan Hexobi posted the other day. But first, we had updates from Richard Hart's attorneys since the motion to dismiss from their end is due here in 6 days on April the 8th. And there was a discovery plan that on the original calendar was due on April the 5th here. What RH's attorneys are trying to do is basically put a stay on that and postpone it, because once they show everything that they're going to show in the motion to dismiss, it wouldn't make sense to have a discovery plan because there's too many issues about the faulty SEC complaint lawsuit that will be debunked, like jurisdiction, among many other things. So yeah, Nuclear Herbs had a really good tweet on it. I think I'll go pull it up here real quick. I was gonna say, I think I pretty much covered what it is there. Let me just see what he said real quick. Yeah. So he said that RH's attorneys are asking to delay the filing for the discovery plan. That's what we said. This isn't entirely surprising because until the motion to dismiss gets decided, you really don't know all of the issues you'll need discovery on. So we said that too. RH's attorneys think that his personal jurisdiction argument has some real teeth, and Nuclear Herbs said before in his Pulse Chain Law School post about this issue. And if RH wins on this one single issue, the case is gone. Again, they feel that there's no need to conduct discovery if they win on that one issue, and they're right. They note that the absolute bizarreness of the SEC having named software as defendants in a lawsuit raises issues that need to be resolved before any discovery should be done. That's another good point, too, that they were listed Pulse, PulseX, Hex as defendants, basically. And then finally, he says, on the flip side, when the court balances the interests of the parties, they're claiming that the SEC isn't being prejudiced at all, which is both mostly true and very important to a court's decision. He says, I'd put money on the SEC filing something claiming the sky will fall if the court grants this stay. It won't be true, but it's not like the SEC's filing true things lately anyway. So he's totally right. And that does, I should have sent that to you. That brings me.
That's okay, because that brings me to this other one, but go ahead and finish what you thought there.
I was just going to say, with his last thought there about, which part was I talking about? Filing claim. About the SEC filing something saying the sky will fall if they grant this stay. We're going to get there because a lot of people seem to think that this is going to be easy peasy and just like wipe our hands of this and the motion to dismiss gets granted and we move on. That'd be wonderful. And I do definitely think that RH's attorneys are focusing on the absolute right things. I think the jurisdiction thing is preposterous. Like, oh, one of the devs or somebody that worked on Uniswap is based in New York, and at least one Hex investor was in the Southern District of New York. It's like, yeah. All right, so let's have it in Omaha. Let's have it in Sarasota. Let's have it, name Boulder, Colorado, wherever you want to go. I'm sure they're all there too. There's that. And then the other issue, naming the decentralized blockchain and DEX as defendants themselves. I mean, they are real things. These aren't, this is part of what we said about this complaint from the SEC is throwing a lot of shit at the wall to see what sticks. That's the shit right there. So if you wanted to, I didn't see what that tweet said, but go ahead with what you had up there too.
Well, no, because later on he says, pay particular attention to this sentence. Richard Hart's attorneys are going to make the SEC prove that they've properly alleged all of the elements of personal jurisdiction with respect to Hex, Pulse, and PulseX individually. They're not going to let the SEC claim that properly alleging jurisdiction with respect to one token gets them jurisdiction over everything, which he says is a very solid tactic and a good move in his opinion. I don't think the SEC thought this through when they drafted their complaint because they were pretty sloppy about how they alleged jurisdiction. And so basically what he's saying is even though that jurisdiction may be true for Hex, they can't just ball it into one thing and treat it all the same, because Pulse Chain and PulseX have absolutely nothing to do with Uniswap. And therefore at least some of those claims should be dismissed. So, if you can narrow some things down and say, all right, you're claiming this, when really you have no right to claim this, and this, you only have this now. When your argument gets narrowed down to just one thing, it's so much easier to fight than just having all these different things come in. So if we can at least get those couple things dismissed, it would be so helpful to the attorneys that are making this case.
Yeah, and it also leads me to this question because on the Uniswap thing, 3 of the tokens, and we've mentioned before, incentive isn't even included in this. So 3 of the 4 tokens, like you said, have nothing to do with Uniswap. Could this also be, and I'm not trying to change the subject, it just happens to go with this, but with some of the recent tweeting of Richard Hart, and it's me, like I said a few minutes ago, feeling like it was ill-advised, could part of it be because of what you just said, that the original OG Hex Classic, which I haven't really heard anybody saying at all lately, that is the only one that's really tied to Uniswap ever, even though it's still an incredibly weak argument for jurisdiction. That is the only one, based on, I think, what his attorneys could argue, that they could have any even remote puny little piddly claim about.
Right. I mean,
do you
there
think that's
is
partially why he
wrapped
did it?
false. I do. I really do think a lot of that, because if he can get that kind of, I don't even say down to zero, but very inactive, and people have moved away from it over to Pulse Chain, the argument kind of becomes, well, no one's using that, man. We
Yeah.
created a new chain, and no one's even using that anymore. So, would it help? Well, I don't know. I don't know if they say, yeah, but you can't say, well, I, there was a robbery over here, but we moved towns. We're no longer there anymore. Well, things still happen, whatever. So I don't know what kind of grounds that holds, but either way, like I said, if you can narrow it down to one thing, there are 4 items. Yes, incentive is not there, but there's Richard Hart, and then there's the 3 tokens. So, there are 4 things that they're really going after. One of them is the misappropriation of funds as well, which again, if he's got receipts, that's pretty easy to prove, right? I mean, that's either you did it or you didn't do it, and here's my proof. So that seems pretty simple. This is, like I said, though, I think this is a big argument to where if you can tell them, well, you don't even have jurisdiction over this, so this shouldn't even be brought up in this case at all. It's going to do a couple things, right? It's going to, like I said, it's going to narrow it down for them. And it's also going to probably create some discredit of the SEC in the judge's eyes too, because it looks like they didn't do their homework at all, and just threw a bunch of stuff together. So they don't like their time wasted either. And if you can make the judge feel like her time's being wasted because they just threw a bunch of arguments together or threw shit at the wall to see what would stick, they don't like that. So it could turn out to be in their favor to just even bring it up. So yeah, I think it's a very smart tactic.
Yeah, I think so too. And you just said too, I mean, the SEC already has lost incredible credibility for quite
Right.
some time now. I mean, I think the judge, it's public information. If you're going to be taking on a case that has a petitioner in it as big as the SEC, you obviously are going to be familiar with what's been going on between the SEC and all these crypto entities, and then you got this lawsuit running congruently with one that's already way further down the line with the SEC versus Coinbase right now, which we're going to get to some developments we saw there the other day. Yeah, I couldn't disagree more with Thomas, obviously, on this point. I know you were probably going to say the same thing. I don't know how else to express this, and I know I'm saying this kind of like in a cursory manner, but I don't think anyone gives a shit about this lawsuit. Like the SEC, it just is not a threat. It's just not, they're losing anybody that they attack in crypto. Everybody knows Gary Gensler is just, I just don't understand how somebody could even think that at this point. Like, we're in a
Right.
bull market now. I just don't consider it a threat. We'll have more to expand upon that in a moment with a poll that was run the other day. But yeah, what do you make of?
Well, I think there are people that are very leery to invest. However, there are a bunch of people like you said, don't care. And when the prices of things go up, and people start rotating into certain things that are still technically a buy, or on sale, I guess would be a better way to put it. Um, the SEC thing isn't going to matter. Now,
Mhm.
new investors, large money, on ramps, off ramps, Coinbases, those type of people care, only because of the legalities. But your normal crypto investors or people, they don't really care. And
Mhm.
I do agree. I I think it could hinder it a little bit, but I don't think we're going to skip a bull market. It may not be quite as strong as we want it to be, but we're still going to see some nice returns. And like I said, I don't think there will be a whole lot. And you know, Thomas, look on the flip side. That is a bad scenario. But what if they do get it dismissed? What if it's dismissed by June or July, or even October, for that
Yeah,
matter?
yeah.
You still have pretty much another year of upside. So I don't think, when you think of the bad things, you also got to think of the good things that could happen too. And remember, there's a powerhouse setup of attorneys that are behind us on this one. So yes, I do agree. I'm holding regardless too, no matter what happens. But um, you know, always keep in mind both sides. And yes, they can drag things out in court, but hopefully we can get it settled a lot sooner, and we don't even have to worry about it.
And things will definitely get dragged out. I mean, not only because of like, the SEC has literally nothing to lose. Like, this, anybody can file a lawsuit against
Sure.
anybody. You know what I mean? So,
And
oh,
unlimited funds.
exactly. And they're in a government entity that, hopefully somebody's going to break up these thugs at some point. But, they have nothing to lose. It's a monetary shakedown where they attack somebody else, in this case, Richard Hart, but they attack other people as well, to shake down technology that they couldn't have ever dreamed of created so they can just get a piece of the pie. That's what it is. So um, I don't think 3 or 4 years. I don't think it's going to take that long.
No.
And like you said, Ewok, I mean, we are in the actually, I think we're in the best possible position with this scenario right now. Like, even think back to December, before Richard came out publicly and said, "Hey, we're fighting the SEC. Here's team of attorneys, and they have 11 different attorneys, some of which have worked with the SEC. Keep in mind, I mean, these are extremely credible people that have
Yeah.
won super notorious law firms. Be happy that you have all that information and know about that information, and that
Yeah.
he has acknowledged it and is totally taking it on. You could still be in the dark about the whole scenario and, not know what's going on. So I think we're in the best possible way we could be with that. Um, that said, something I want to say, because I think people are getting a little over eager sometimes. I see. Here's the thing with these kind of things: there's always a middle ground, and that's usually there's a middle ground that's like 80, 60 to 80% in the middle, and that's usually what's going to happen. Then you have 20% out here. Oh, hey, this could take 3 or 4 years. We're going to miss the bull market, and then over here you have this is going to get dismissed on April 8th. No, I say no to both of those scenarios, but
Yeah.
let's juxtapose Thomas's point there with what we're seeing on Twitter. You and I were talking about this the other day. I think people need to stop with this. Hell, what if it gets dismissed this month? How many X's do we do? I think the chances of it getting dismissed this month are absolutely, like, minuscule. Yes, the motion to dismiss will be due. It will be very interesting to read that. I'm excited to see that. We'll all kind of be, checking out the Nuclear Herbs Twitter to see what his thoughts are on it as well. But it'll be really interesting to see what it is they have planned. But a judge still has to sit with that. There still is a timetable. The SEC has, I think it's until July or something like that to respond to the motion.
Right.
So, I mean, yeah, these people that are getting giddy about that right now just because the motion to dismiss is due, I would cool your jets a little bit. The SEC, like we already said, they have nothing to lose. They're going to postpone, draw it out as long as they can, and wait until they get a little payment and probably then walk away or something like that.
And don't forget, the amicus brief was brought up as well. We can talk about that. They are mentioning that 43. They mentioned the number 43,000, I think, for a reason.
Yeah.
And I would love to see us get to 50 by the time it gets anywhere further. Just to say, well, it was 43, now it's 50,000. And there's another one, I believe, that Coffee's group has started as well. So we'll have 2 amicus briefs in our back pocket, pretty much.
So I don't know if that one is Coffee's group necessarily. I know he tweeted about it, but it is from like an organization called I Can. I should have looked further into this, but yeah, it's basically it's a model set up where I'm not saying that pulsepetition.org won't be taken at all seriously. I think that it can and will be in some respects, but this other organization has, a lot of other things I think they've done under their belt that would lend itself to even more credibility, is I guess what it is. But
yeah, I didn't look into who they were either, really, and I shouldn't have said Coffee's group. Coffee was the one that retweeted it and mentioned them. So yeah, I misspoke there. Sorry.
No, it's good.